time for rebuttal.
Yes, Your Honor. With the court's permission, 5 minutes, please.
All right. I might as well go ahead and get this out of the way now. How about counsel for appellee? Any time for rebuttal?
I think 3 minutes should be sufficient, please.
Very good. Now, keep close eye on the clock. The colors can sometimes be a little deceiving, so you have to know where the lights are. The green, amber, then red. Some people misconstrue the colors, the amber and red, and misread them. So keep a close eye on that. I will as well. So with that, appellant, are you prepared to proceed?
Yes, Your Honor.
Please do so.
May it please the court, it's Jeffrey Michael for Philip Morris USA. This is an appeal of over $8.5 million award in fees and interest in an Engel progeny case. We raised numerous issues in our brief, but I'd like to start with the threshold issue of whether plaintiff was entitled to recover fees under the proposal for settlement statute in the first place, which is an issue that this court reviews de novo. Our argument that the 2010 proposal was invalid is, I think, very straightforward and based on a plain text reading of the proposal itself. And the specific textual provision says that the proposal will be deemed withdrawn unless the defendant serves written notice upon the plaintiff within 30 days from the date of this proposal, of this document, that the proposal is accepted. So after 30 days, the proposal itself said that it was withdrawn, and the 30th day was December 24th. The problem is that our time period to accept the proposal would have been extended to December 27th were it not been withdrawn by operation of 1.090, given the holiday and intervening weekend. Now,
the petition basically tracked the statute in the rule, didn't it?
Well, the language doesn't precisely track the statute in the rule because the language uses withdrawn, whereas the portion that plaintiff is saying they're tracking says rejected, shall be deemed rejected, which is actually language that they used in their other proposal, but not this proposal. They used withdrawn. So it doesn't track in that respect. And it says from the date of this document, whereas the proposal itself, the statute and rule itself say from the date of service of the proposal.
And there's nothing in the record about knocking on the door on the 27th and trying to accept that I understand. It's just about whether it was withdrawn on the 24th.
Correct. But it is interesting to think about what would have happened had we said on the 27th, we accept. And in the intervening period, say that the plaintiff, because of a change in the case or for whatever reason, had decided, you know what, I want to get out of this offer. Plaintiff at that point would have had the ability to say, given this provision in the offer, well, wait a second, after 30 days from the date of the proposal, it was withdrawn. So no, we don't believe that you can accept, which would have, obviously resulted in litigation at that point, but it would have been a pretty substantial argument on their behalf. And a proposal is essentially a contract that must be interpreted under its terms, not, hey, no harm, no foul, because you didn't try to accept. You have 30 days, it's withdrawn, and it's not just the plain text contractual provisions. That
Is there ambiguity in this contract, given that they said, I think a couple of times that it was pursuant to the statute and the rule?
Well, I think it's plain text is that it was withdrawn at the end of December 24th. But if you're getting into the question of whether you should interpret plaintiff's purpose and including that and try to determine whether its purpose was to withdraw on the 24th or 27th, to that extent, then yes, it is an ambiguity. And you've got, the proposal is under a sanction statute that is contrary to the American rule that parties pay their own fees and subject to not just then the strict construction of any contract or statute, but sort of an uber strict construction under the case law regarding proposal for settlement statutes. So certainly under that construction, if there was an ambiguity, it should be interpreted against the offeror.
I could ask, when did you first point out to the trial court the argument you're making? Was it soon after the 27th had passed, or was this at the very end of the case, sort of like, hey, oh, now we notice that there's a problem here? I mean, when did you bring it to the attention of the?
We brought it to attention in response to plaintiff's motion for fees after the judgment was entered. That is always when the validity of a proposal is litigated. In fact, the statute and rule prevent you from actually filing the proposal for settlement prior to plaintiff seeking or whoever seeking to enforce fees filing a motion to enforce the fees. So I don't know of any context where that could have been done earlier.
There's no mechanism. You're saying there's no mechanism by which you could have contested it earlier?
Not that I'm aware of. Now, it's fairly routine to have multiple offers of judgment, sometimes in differing amounts, sometimes with differing language, like you had in this case. So plaintiff served more than one proposal for settlement. They served 2 here. They could have served 3 or 4, and in that case, could have attempted to solve this problem. If, obviously they changed the provision for some reason between July and November. We don't know why. There's nothing in the record on that. But the burden certainly was not on us to say, by the way, you have a potential flaw in your proposal. Why don't you go ahead and do it again? Right. And so plaintiff doesn't take issue with the fact that we had until the 27th to accept. What plaintiff's argument is that the proposal would have been withdrawn on the 27th as well, which is an interpretation of Rule 1.090, which again is a legal issue, which is whether or not the proposal was computing any period of time prescribed by or allowed by the rules. This was not a period of time that the rules required or allowed. It didn't say within 30 days you're allowed to do something. This was something that was constructed by the plaintiff, so Rule 1.090 does not apply. Just like in the Smith case we cite from this court, an insurer who said to the insured, you can make up your payments within a certain period of time, and that time ran on a Sunday. The trial court said, well, that gets bumped to Monday because of Rule 1.090. And this court said, no, it doesn't, because that was a contractual provision, not a provision under the rules or statute. So if there's no more questions on that entitlement argument, I want to move to the amount arguments that we raised. The trial court here awarded up to $950 an hour. And it's obvious that something went wrong because you had counsel for plaintiffs, Mr. Mills, billing at the time as his standard rate, $500 an hour for general commercial appeals in 2015. And in 2016, accepting $500 an hour for the Staines Engel progeny case, which was from Duval and resulted in appeal to this court. So you have such a massive disconnect between rates that are actually being charged by plaintiff's counsel in Engel progeny cases and what the trial court awarded. And of course, the 4th DCA we cite in another Smith case as saying perhaps the strongest and best evidence of an attorney's market rate is the hourly rate he or she charges clients. So how did the trial court get to such a disparate result? The first mistake it made was that it took plaintiff's expert testimony that it recognized was flawed because it included the contingent nature of the representation, the time and labor required, the novelty and complexity of the case and results obtained, to come up with $1,000 an hour opinions. And the trial court recognized that that methodology was flawed, but instead of rejecting it with no evidentiary reasoning, said, well, I'll chop off $25 an hour or $50 an hour. There's just nothing in the record that supports that small amount of change. The second, now, so well, I guess what happens when the trial court realizes that plaintiff's expert was flawed? You have two possible remedies at that point. One remedy would be to say, well, it's plaintiff's burden to prove the hourly rates. Plaintiff was required to do expert testimony and failed. Therefore, plaintiff has failed to meet her burden, and the result is no fees. The other thing you could do is say, well, there is evidence regarding fees in the record, hourly rates beyond plaintiff's expert. There's requisite expert testimony from Philip Morris, from Mr. Colgan, that had alternative rates. And so the other potential remedy is to say that, well, Mr. Colgan's rates, which Philip Morris is, by proffering him, agreed to, should control the question.
Well, did Philip Morris's expert, did your expert actually provide testimony with respect to this case, or basically say, I'm testifying in general, but I have no opinion with respect to this case?
Yes, Your Honor. It's sort of a mix of the two. He testified that it was specific to this case in the sense of it was specific to Jacksonville, Duval County, a complex civil litigation. It was not specific to this case in the sense of the Mary Brown case individually. So it was a general lodestar analysis that then under 76879 or 1442, a trial court does have the ability to change the end result of the lodestar based on the listed factors. But I think that Mr. Colgan's opinions as to the prevailing rate in Duval form the basis of the lodestar. So we would say that that was a sufficient proffer of expert testimony.
Whereas on the other side, if the judge would have been able to tie the $25 discount back to the expert, and the expert said, yeah, I bumped everybody up 25 because I looked at all the factors instead of just the ones that I should have, then there would have been grounding in the record for what the judge did.
That could have formed substantial competent record evidence. We would still have our other challenges to his opinions.
Sure.
Well, if I could ask a question, I thought at some point the trial court was given the discretion to choose current rates or the rates that were used throughout the litigation. I mean, this case is a decade old. So he chose to use, or chose to consider current rates. He didn't actually adopt current rates. So he adopted some level of rates somewhere between current rates and what the rates were at the time of the services provided. So where did he abuse his discretion in doing that?
Well, Your Honor, first, they rely on a single case from the 4th DCA, Bogeroff, that the trial court could use current rates. No PFS case says that, and the statute says fees that were incurred, which means you pay what they were incurred at, and then interest from the judgment interest statute can give you extra for delay. Here, the trial court erred by doing both. But I would say that Your Honor's premise that the trial court considered but did not use current rates is actually incorrect. The trial court's initial order said flat out that the trial court was adopting current rates. This court elects to utilize plaintiff's timekeeper's current billing rates when fixing the reasonable calculation in this case. That's in our appendix at 43 and in the record at 8042. What happened was after plaintiff's expert only testified on current rates, and the trial court said, I elect to use current rates. Plaintiff said, we want interest from 2015 on top of the current rates from 2018 that we proffered.
And that's a different issue, right?
Well, but that's how we got to the place where at that point, plaintiff, I think, realizing a weakness, and the trial court realizing a weakness, went back and said, well, you know, I'm not sure. I didn't really use current rates. I considered them, so I'm going to give interest back. But there was no expert testimony from plaintiff's side on 2015 rates. And the trial court didn't give the reason that he chopped off $25 to $50 an hour as I'm blending past rates with current rates. What he said was the methodology was wrong on contingency, novelty, time and labor required that contravenes Roe. So I'm going to chop it $25 to $50 an hour. So I think it's, if you really just look at the orders, it's plain that plaintiffs got both current rates and interest from 2015. And on top of that, the rates were current in the sense of not only inflation to present, but also maturity of the lawyers, which for some of the lawyers, the more senior lawyers might not matter. But for the junior lawyers, you have, instead of 2015 rate for a third year associate, a 2018 rate for a 6-year associate, and examples like that, which essentially triple dip. You're increasing the rates 3 times based on delay.
Counsel, you're 1 minute over your 5 minutes. You can continue, but if you want to reserve the time, please do so.
I will reserve, Your Honor. Thank you.
Sure. Counsel?
Thank you, and may it please the court. I'm John Mills on behalf of Mary Brown. As to the main appeal, which challenges entitlement on the second proposal for settlement, that proposal clearly was just referencing the period of time allowed by the rules for withdrawing a proposal. You have until it expires, which is 30 days. And it just falls right under Rule 1.090, which says you calculate periods that are allowed by the rules by excluding the last day if it's on a legal holiday or a weekend. That clearly applied to our time frame because we were talking about a time frame allowed by the rules. This is just happenstance. This is, when we first got this, we're like, what? You just have to look at a calendar, and it's the happenstance of the year 2010 that we had this, the calendar work out this way. It could have been served on any other day, and we would have had the same period, and I don't think we would have an argument here. And my brother has not addressed a case that I think is just directly on point on this, certainly on their alternative point that when we said it was withdrawn on Monday, that means it's withdrawn before the time to accept expires. That was rejected by the 3rd District in 2015 in the Russell Post property case. We cite that. It made it very clear that Leaders Bank, whoever the appellant was in that case, had raised the argument that by saying it was withdrawn during that time period, it's invalid. And the court rejected that exactly. It's the same argument. And really, I think while Judge Jay was clearly correct on the second proposal, he was mistaken on the first proposal, which is the subject of our cross appeal. And because that was served earlier, that really renders the second proposal that we were just talking about moot or harmless, because the first proposal was very clearly valid. And I think that Judge Jay succumbed to what a lot of trial courts and appellate courts were doing at the time, which was nitpicking these proposals. And if you could find some provision that in isolation was ambiguous, it would tear down the whole thing. But since that time, the Florida Supreme Court in the Anderson versus Hilton case has held directly to the contrary and said that when the context of the rest of the proposal or the claims that are pled in the complaint are looked at, then it still has to be a reasonable ambiguity. And if context answers the question, then that ambiguity is not fatal.
Does it matter that the ambiguity here went to a fairly important term? This was getting rid of claims as to A, and then it said getting rid of claims as to B. Whose claims are we getting rid of? That's fairly fundamental.
Well, I don't think that's a correct way to characterize what this is. Certainly, whose claims are being settled is as material an issue as there is. But it's not ambiguous. I don't even think it's a forced ambiguity when you're looking at the language. Both in the proposal and the attachment, they interchange whether these are his claims or her claims. The her referencing Mary Brown as personal representative, the him referencing Rayford Brown as the decedent. They are interchangeable terms. His claims are her claims for all purposes. They're his claims in the sense that he is the victim, and they're her claims in the sense that she's the one who brings them. But either way, the only claims that have ever been in this case are the wrongful death claims. There's not been a survival claim ever pled here. And this use of the term individual claim, which they say creates an ambiguity, is patently a reference to the other individual claims in this complaint. This complaint was filed on behalf of about a dozen smokers and plaintiffs. And he's just saying, the proposal just says, this settles the Brown case, not these other cases. That's all it means. Individual claim does not mean a survival claim versus a wrongful death claim. Either survival or wrongful death are still individual claims. They're claims belonging to an individual. And so there's just no ambiguity here. Paragraph 2 of the proposal says what it's settling, and it says it's settling plaintiff's claims against defendant Philip Morris. The only claims ever said were wrongful death claims. There's no ambiguity. If they had accepted this proposal, it would have ended the case. Could we have taken the position, or could a court have said, oh no, that just settled the individual survival claim that nobody ever pled, and it hasn't dropped the only claim that was pled? That would be preposterous. The only reasonable reading of this proposal is that it was to settle Mary Brown's assertion of claims involving the smoker Rayfield Brown. However you word it, and in both the proposal and the attachment, it worded it both as his claims and her claims within the same two sentences in both places. So that was very clear. This court in Floyd v. Smith says using the wrong pronoun, his or her, when it's clear from the complaint who you're talking about, is not a fatal ambiguity. That's directly on point.
If I could ask you, if the proposal said that this settles claims as to A and B, and let's say B is not even a claim in the litigation. I mean, that's sort of what we have here, where the proposal says we're going to settle one claim and the second claim as well. But there's not really this second claim. Does that render it fatally ambiguous?
Well, this doesn't make any reference to a survival claim. Nowhere does it say survival claim. They're saying individual claim means survival. I don't know where they're getting that. I've never heard of a survival claim called an individual claim and a wrongful death claim not being individual. So this is not the kind of proposal that you're talking about, Judge Makar. Now, had this proposal said this is to settle the claim we've pled and any other claims or some other claim that we haven't pled, well, then that might come into context, but we don't have that here. And even if we did, it says this settles all the claims. Plaintiff agrees not to assert any claims at all against Philip Morris.
I mean, this is not a case where Rayfield Brown was alive at the time the lawsuit was filed, then died during the lawsuit. Correct? He was already deceased at the time the lawsuit was filed.
That is correct. This was a wrongful death. All of these were wrongful death cases ab initio.
So the only claim really was the claim of his estate.
That's right. The only person who he was dead, so he doesn't have any claims to dismiss. She is the personal representative who can assert the claims on behalf of the estate. Now, those claims could include, in a case, both a wrongful death and a survival action if there's uncertainty as to the cause of death, but there was no uncertainty here. Rayfield Brown died from smoking cigarettes. That's not ever been disputed here. This wasn't a case of, oh, he died because he got a cold while he had a smoking disease. He died from the smoking disease. So there was never even an issue of there being a survival claim here. If there are no other questions on entitlement, I'd like to turn to amount, and I'll start where my brother started, which is about my testimony and my rates. I keep reading this, that our rates were $500 an hour. That's not what the evidence in this case is, and that's not the case. Our rates in non-tobacco, non-contingent, standard off the shelf, you get paid within 30 days, win or lose, went from $500 to $800 during this time period. But the evidence in this case was our fees in cases like this, which is what the rules say we're supposed to look at, is cases of the same or similar nature. They were what we sought, which was $1,000 an hour for me and $700 for Ms. Brewer. And this is, we have a cross appeal on this. The judge reduced it. I'll talk about that in a minute. But there was ample evidence. In the Staines case before this very court, I charged these exact rates. These were our rates in that case, and they were contingent just as this case is contingent. Now, as I testified, we modified that fee in the middle of the litigation to provide, it was originally, that was a non-contingent fee. And as that case got to take many, many hours, and this was a case before this court, you can see how many hours it took. My client said, hey, that's an awful lot for me to pay, win or lose. This is more than we thought it was going to be. And so I agreed, we'll only make half of that rate non-contingent. You pay me that right now, win or lose, pay me today, which they did. And they would agree to pay the other half if we won. Now, we didn't win that case. And since we filed the brief, the Supreme Court denied review in that case, so we'll never get paid that second half. But the point is, that was our rate in a tobacco case if we were successful, which is the same rate we seek here. In other cases, the Anderson versus Hilton case I testified about, that's the case I was just talking about when the Supreme Court said the ambiguity in a proposal for settlement can be resolved by context. That case, the same rates. It was contingent, $1,000 an hour for me, $800 for Ms. Brewer, same time frame, 2015. We won that case. They actually paid those rates. So my brother is correct. That is the best evidence, and that evidence supports our rates. There was another case. I had a fee dispute on behalf of the Burlington and Rockenbach firm. It was a fee dispute between attorneys. I handled the oral argument in that case on a contingent fee basis for the same rates we're seeking here in 2015. We won. We were paid those rates.
Well, counsel, if you could address the point about, they're trying to say, well, look, you all sought these rates and they put up alternative rates, and the trial judge made a mistake and cut $50 here, $50 there. How is that supportable what the trial judge did to take $50 here, $50 there?
Well, I have two answers to that. The first answer is the direct appeal response, which is there was plenty of, this falls within the judge's discretion. And if you assume that he is correct, that those factors cannot be considered, then he just exercised his discretion and said, well, your expert testified and everything he said was credible and I believe, but he did say these factors, he took them into consideration, and I find he can't take them into consideration. And applying all the factors, he says he applied all the factors, he made his determination, and that determination was supported by competent substantial evidence. It was below the rates that Mr. Edwards testified to. And importantly, Mr. Edwards said, in taking it all into consideration, he felt that we should have charged higher rates than we were asking, that a much higher rate would have been supportable under all the factors that he considered. So we already were seeking less than he thought was reasonable. And the trial court identified factors and said, these aren't applicable. And when I take these out, this is what I get. And that's the discretion that he has.
So the trial court didn't have to say here, okay, I'm going to reduce it by $50 an hour. $10 of it comes from factor A, 20 comes from factor B, and 20 comes from factor C. I mean, there's the case law, I don't believe, supports having to make that kind of demarcation. The trial judge can basically say, I consider factors A, B, and C. I dock the fees $50 an hour.
That's my understanding of the law. I think that's very clear, yes. And he says, I've considered the factors. He identifies the factors he said were improper. And he says, when I take these out, the remaining factors support this fee award. And again, the fee award is for less, at least with respect to the appellate fees, it is for less than what clients are paying us in similar cases. So it's clearly supported by competent and substantial evidence.
Now, is the fee, the standard here, fee customarily charged in the locality for similar legal services, that's maybe something different than the fee charged by boutique Engel type law firms that you're among, as are attorneys from the other big cities around the nation, right? It seems to me that this standard is a little bit more relaxed and local and generic than these boutique players who are all congregating for a lot of these cases.
No, I would disagree. Rule 4-1.5 B1C expressly says the factor is the rate of fee customarily charged in the locality, but not just in the locality for legal services of a comparable or similar nature. So the issue is, are Engle progeny cases sui generis? Are other cases that aren't Engle progeny, or certainly that aren't against tobacco companies, comparable or similar? And the trial court determined that they were not. And that finding is supported by competent substantial evidence. Mr. Edwards went at great length to testify about what's unique about these cases and why he himself is a products liability lawyer who won't touch these cases because of the specific unique factors here. And this court, from Judge Makar in the Sofer case to the Middle District of Florida, Judges Corrigan, a 3-court panel in the sanctions case, said these cases are like no other. They are sui generis. We give explanation after explanation from the case law about why these cases are so much more difficult and expensive to litigate. They require special expertise to see how all of these legal issues that are unique in light of Engle, how they interplay, so that in arguing on one issue, you don't argue yourself into a corner on the other issue. You have to have command of all of these things. And we also have the decisions that recognize the defense strategy of these defendants, the patent strategy, to make the other, quote, son of a bitch spend all of his money. They drive up the expense, they fight everything, they have a special bond statute that allows them to escape paying all the way until they exhaust US Supreme Court review, and it's a war of attrition to see if these attorneys will tough it out. And that's what requires us to charge much higher rates.
To clarify, you were quoting a case. You weren't just using those words out of your mouth today, I hope.
I was quoting a case which quoted one of the defendant's lawyers, who in turn was quoting General Patton.
Great. Thank you.
Yes. I'm sorry if that was a broach of decorum to use the B word there.
I didn't want it to be misconstrued.
Thank you. It's a colorful quote, but the point is that they are trying to drive up the cost specifically to dissuade attorneys from taking on these cases. That's why these cases are sui generis. Now we have a cross appeal. Let me just real quick on the current rates. The current rates, the judge made very clear when we sought interest, they said, oh, that's double dipping, because and the only extent there could possibly be a double dipping claim is the time between 2015 and 2018. And we just told the judge, we said, Judge, look back, the testimony, you said you considered current rates and you awarded current rates, but our current rates in 2018 were the same as they were in 2015. And so ruling on that argument, he made that point. He said they are the same rates. So yeah, I applied the current rates, but they were the same as would have been reasonable in 2015. And, you know, we have another case pending in this court. There's the docketing statement shows they're related. It's called Jordan. Same lawyers, you know, my brother here's in that case, same trial judge, same trial lawyer, same everybody, same expert, Tom Edwards, same judge. And Mr. Edwards came in and said, all right, not considering those factors, same rate. The judge found same rate. You know, you'll be hearing all these arguments again. I think we're on the answer brief in that case. The court made very clear there's no double dipping here. And this isn't just Borgorf. The US Supreme Court and the 11th Circuit said courts across the country regularly determine fees when there's a delay like this, one of two ways. Either use the historic rates and adjust them for present value, which involves a laborious year by year, apply different rates, figure out, you know, you have to have an expert come in on all of that, or just a simple lodestar like we always see, one rate, 1 hours, multiply it out based on current rates. And that's what the court did here. It didn't do both of those. It only did one. And that gets you for the delay from the time they rejected the proposal for settlement in 2010 until we got a judgment after 5 trials and all kinds of evidentiary hearings and post-trial hearings. We finally get a judgment in 2015. So current rates.
Would your Would your argument be different? It seems to hinge on the fact that the 2015 rates were the same as the 2018 rates. So your argument would be different if we were talking about 2018 rates that were different from 2015 rates, putting interest on top of 2018 rates.
No, I wouldn't concede that point. I think the court is still correct. They serve different purposes here. I'm just pointing out that this is a colorable argument that they're making, that in that window of time, if it was a different rate, if the rate went up from 2015 to 2018, if you both use that higher rate and you award interest on it, for that little period, you have some degree of double dipping. And I think as a matter of fact, that might actually be the case. But they serve different purposes, and I think even then it would be okay. My point is this case just doesn't present that problem because there wasn't any double dipping here. We got the 2015 rates based on work through 2015, which is when we had the right to fees, and then we got interest, which is non-discretionary. It's discretionary on whether to use the current rates, but the award of prejudgment interest is just, there's a statute on it, we're entitled to it. The French case says it goes from the date of the judgment, and that's what we get. And that accounts for the delays, the loss of the money during the appellate process.
Okay, counsel, you're down to 1 minute. So what I'm going to do is we'll stop the clock. We'll give the other side an additional minute and give you an additional minute.
Okay, I would just like to say that
save it for the last 2 minutes, okay?
okay, I just didn't want to raise something he would have a chance to.
Unless you want, we're going to add a minute to both sides now, but we're going to turn to the appellant.
Okay, thank you.
Okay. Thank you, Your Honor. Let me start with the interest issue and the current rates issue. The trial court's order cannot be more clear that the court elects to use plaintiff's timekeeper's current billing rates. Plaintiff's expert only testified about current billing rates. So what are the record sites and what's the place where the trial court said, well, the rates were the same in 2015? That testimony came from Mr. Mills and Mr. Shields, plaintiff's counsels, that their internal rate that they said we seek and to get fee awards was the same in 2015. There's no evidence regarding what the customary rate charged in any locality was in 2015. So I'd encourage the court, if you are going that route, to check the record sites on that. I was challenged on the Russell Post case from the 3rd DCA with respect to the 30-day withdrawal provision. In that case, there's no indication that there was a difference between the 30 days of the acceptance and the 30 days of withdrawal. It's one of the cases, like Mr. Mills hypothesized, where the date fell on the same day. So that case wouldn't control this court irrespective, but there's factually no connection to this case. On the July 2010 proposal, so the representation was made numerous times that there was not an alternative survival action pled. There was and there wasn't. There was in the sense that the complaints said, alternatively, in the event one or more of the defendants contend that the decedents died of some cause unrelated to smoking cigarettes containing nicotine, plaintiffs assert a claim for survival damages pursuant to 46.021, and that's repeated in each cause of action. So there's certainly survival claims in the complaint. I guess you could argue that they were not triggered until we contested smoking cause, but irrespective, we've got a proposal that says you accept this and we will file a notice of dropping Rayfield Brown's individual claims in the trial court. And so then what would have happened if we accepted and that got filed and plaintiff said, well, we dropped his individual claims, which are their survival claims. Wrongful death claims are for the daughter. Survival claims are for the smoker. That would have been a significant argument that we would have had to try to overcome. We wouldn't have known if we had actually bought peace. And that notice of dropping was also quoted in the actual proposal. So especially under strict construction, I think Judge Day was correct that the 2010 proposal was invalid.
If I'm hearing you correctly, counsel, are you saying there's a survival claim in the complaint?
Yes, yes, Your Honor.
Well, then I thought the argument was that the proposal to settle includes a survival claim.
No, Your Honor, it's that the proposal for settlement says, if you accept this, we will file a notice of dropping Rayfield Brown's claims against Philip Morris USA. And so that did two things. It created an ambiguity, and it also made it unclear if it would resolve the whole case, because these claims included Mary Brown's claims as PR, which included a wrongful death and an alternative survival claim, which was essentially Rayfield Brown's claims. So the question is, and this, we had the Staines case referenced. Rayfield Brown was an individual smoker. Some cases were brought by individual smokers even after they died. And it created a question of whether, if they filed a notice of dropping Rayfield Brown's claims, would they have actually been dropping just the survival action or the wrongful death action, or what would have happened? It essentially created an ambiguity. And the onus is not on us to clarify that ambiguity. And I did just want to say, there is not record evidence, and I again would implore you to check the record sites, of plaintiffs being paid by paying hourly clients $1,000 an hour, $950 an hour in an Engel progeny case, in general complex civil litigation in Duval. This is not sui generis compared to every other case that's ever been pending in Duval and Jacksonville. And
Thank
so
you.
I request that the court reverse. Thank you.
Thank you. All right, let's see how much time we have left on the server bottle. Almost 2 minutes. Go ahead.
All right, thanks. I will limit this to the incorrect statements of my counsel that relate to the cross appeal. I don't think it would be appropriate for me to address the ones that are on the main appeal. But on the cross appeal, this is what the notice says. Just read the notice. It was attached. It doesn't say anything about survival claims, and it doesn't have any ambiguity that it dropped Mary Brown's claims. It says the plaintiff, Mary Brown, as personal representative of the estate of Rayfield Brown, hereby drops her individual claim against Philip Morris. It says she drops her claim, whether that included an alternative survival claim or not. And it didn't, because they never denied that he died from smoking. So there wasn't an alternative claim, but we said, if they're going to do that, we'll assert it. But regardless, it says it's dropping her claims. And then it has a second sentence after that that just clarifies it's not dropping the other claims that are in the complaint of all the other smokers. It says the dropping of this claim with prejudice pertains to Rayfield Brown's individual claim, and it gives it the case number, which has a different suffix, the BXXX, to distinguish it from the mass complaint, which has the same case number, but without that suffix. So it's eliminating ambiguity. They went to great pains here to make sure there was no ambiguity. This ends the litigation. This gives you peace. It says Mary Brown won't pursue any claims. She's the only one who could pursue a survival claim. It doesn't suggest there's any difference between wrongful death and survival. And Mr. Michael has no answer to why he keeps saying that individual claim means survival claim. It doesn't, and there's no reason to interpret the language to make that distinction. And with that, I would ask, we do ask for reversal on cross appeal. It would give us some extra hours, and we'll rest on the briefs for those impermissible factors.
Counsel, we appreciate your argument today. The case is now submitted.